Broadly speaking, the changes in the Competition Amendment Bill could be classified into three buckets. The first bucket, which I also call housekeeping changes really, are those changes which were necessitated due to certain judicial precedents, or there were certain obvious changes which were already under implementation by the CCI. One such example of change is inclusion of service within the ambit of vertical agreements that now CCI can also look into. The second bucket comprises of certain procedural changes. For example, now the CCI can send a DG report back to the DG for re-investigation or further investigation even before the report has been shared with the parties. Previously, that was not possible. The third bracket relates to substantive changes to the Competition Act, and these are changes which affect rights and liabilities of the parties and would include changes such as introducing a limitation period to bring in a case before the CCI. There is one important change each with respect to horizontal and vertical agreement. With respect to horizontal agreement, now even a facilitator of a cartel could be proceeded against under the Competition Act, which was not previously possible. The result of this would be perhaps in a hub and spoke kind of cartel arrangement, where very often the hub which drives the information flow with respect to the cartel is not at the same level of production chain or is probably not in the same substitutable business, can also be proceeded against. With respect to vertical agreement, the important change is that the distinction between vertical and horizontal that was previously created is really now going to be horizontal and non-horizontal agreements. Meaning thereby, the law now seeks to introduce any agreement of a third kind which neither falls in the domain of a horizontal agreement nor falls in the domain of a vertical agreement. Even those kind of agreements are now subject to and amenable to the jurisdiction of the Competition Commission of India. There are two important proposed changes. The first relates to the ability of a leniency applicant to withdraw its application altogether. While this might appear to be counterintuitive, this could be useful, especially in cases where after a detailed internal investigation, the party later on finds out that its involvement in a alleged cartel would have been rather limited. In such cases, it might be prudent for a party to choose to withdraw its leniency application altogether. Although the Commission cannot use the admission made in such cases against the party, it can certainly rely on any evidences that have been furnished as a result of the previous disclosure. The second change in the leniency regime that is proposed and relevant to our consideration here is the leniency plus provision. Now, the proposed amendment states that when a cartel conduct has been disclosed for, say, conduct A, then if that party discloses a fresh conduct, say with respect to conduct B, then it will be able to benefit as a result of the freshly disclosed conduct, even with respect to conduct A. Therefore, what it means is that even though conduct B's disclosure will have its own standing and the party might be able to benefit from the leniency regime with respect to conduct B, even with respect to conduct A, where the party may or may not be the first applicant or may not have an early marker status, even in those cases, because it has disclosed a new cartel, the Commission can consider it and value it appropriately while imposing lesser penalty on it. I would like to discuss three provisions in this regard. First, introduction of a limitation period. The bill proposes that now the Commission would have discretion to entertain only those complaints which have been filed within a 3-year limitation period from the date on which the cause of action arises. Although in appropriate cases, the Commission can entertain cases older than that also. The second provision that I would like to discuss is regarding the discretion of the Commission to not entertain new cases where the issues are of a similar nature which are already pending before it or have already been decided by the Commission previously. The third provision which I would like to discuss is regarding settlements and commitments. Both these provisions will apply only to non-horizontal agreements and abuse of dominant position. Out of the two, settlement is obviously of a more serious kind, which involves a payout from a party. Settlements will be possible only when the Director General's report is out and the party can assess that its involvement in the conduct is serious enough that it should go ahead and initiate a settlement process with the CCI with due consultation. On the other hand, commitment is something which will be offered by the party right at the beginning and at a stage when the matter has been just referred to investigation, and the parties will have an option to negotiate with the CCI as to the terms of commitment so that any market impact that the potentially anti-competitive conduct could have could be abated in the market. Both these cases do not have any right to appeal, and in appropriate cases, the Commission may even revoke the settlement or commitment. Therefore, it's a risky proposition for a party in that sense, but obviously much is left to be regulated by regulations, and we will have to watch out this space in the future to see how this jurisprudence evolves with respect to settlements and commitments.